Welcome to What to Do When an Employee Gets Arrested. I'm Mike Coffey. I'm president of Imperative Information Group, the best darn little background check company in the country, premium background checks and fast and friendly service. But I'm also an HR guy who just happened to get into the background screening business 23 years ago. But I still spend a good bit of my time working with employers around their employee selection issues and employee relations issues, the fun side of HR. I stay away from any part of HR that has numbers attached, benefits, comp, any of that. But and obviously I spend a lot of time with my clients talking to them about how they use criminal history, about their background screening process and things like that. But this topic today is one that comes up a lot because employees get arrested sometimes and employers don't know what to do with it. Before we get too far into that, though, it's important for me personally, to stress to you how important I think it is to be a second chance employer, or a fair chance employer, if that's the term you like. And you probably already are. I mean, I think most employers are second chance employers. They just don't know it. They have employees who've had issues in the past, who've had some sort of interaction with law enforcement, got arrested, maybe pled guilty or paid a fine, did something like that. And a lot of employers, don't ask, and they've got a don't ask, don't tell kind of policy. And if you've watched any of my webinars, and the whole series is on our website, you know that I'm opposed to that idea. You need to know, you need to make well-informed hiring decisions, but making a well-informed hiring decision is good business practice, but it also means that well-informed hiring decision, the well-informed part, goes hand in hand with the fairness part by having good information from your candidate and then verifying it through Imperative or whoever your screening company is. It's really key to be fair in that process and say, what is the relevance of this offense to this job? Having this person in this role, what risk does that present to the organization? Is that a risk that's easily mitigated, or is it a risk that as an organization we really just can't afford to take? And there's a job for everyone out there, but not everyone is fit for every role, either because of their competencies or their education or their experience, but also because of some of the decisions they've made in the past that would be really challenging for an employer to put them in a certain role, even into the future. So I'm a big proponent of fair chance or second chance hiring. That's what a big part of this whole webinar series is about helping employers be fair in how they evaluate criminal history, so they're not losing candidates unnecessarily or excluding candidates unnecessarily, making it harder to hire and fill positions, but at the same time that they're protecting their customers, employees, the public, their own assets, their company reputation, all those things. So just right up front, I'm a big advocate for that. I help employers write their policies around the use of criminal history in a way that is fair. Got that as part of our consulting program. So just want to promote that at every opportunity. And so in almost all of these webinars, this is like the second slide to make sure I'm getting that message across. So what are we going to talk today? Well, we're going to talk about when an employee gets arrested, right? So first, we're going to talk about terminology, because so often I'm talking to employers, or I'm talking to applicants, or even individuals with criminal history, and they start using a term, and I'll use a term, and they don't understand what I'm saying. But often they're using terminology, and it's not really the right words. And in the words of the great Inigo Montoya from the excellent top 5 movie for me, The Princess Bride, he says, "You keep using that word. I don't think it means what you think it means." So we're going to spend some time around terminology, because that gets confusing for employers sometimes. And then we're going to talk about the legal considerations around how you use criminal history and an arrest record in the employment context. Because often you hear, oh, an employer, we can't use arrest information. Well, that's not quite so true. And we'll talk about that. We're going to talk about the different ways employers may learn about arrest information. And some are, intentional and some are unintentional, and we'll talk about those. And then, but once you know about it, what are you going to do about it? You need to do an investigation. What does that look like? And then determine how that arrest may implicate some risk for the organization. And if it does, then how do you respond to it? What are our options as an employer in responding to it? So that's what we're going to talk about today. So let's get into the terminology. And the lowest level of criminal offense is basically a citation. And so if somebody was cited, they got a ticket, basically. These are typically offenses that are the lowest level misdemeanor. They don't involve any jail time unless somebody fails to show up for court or something like that. So public intoxication is often one, if they're not just falling down drunk, or open container in public in some cities is illegal. Things like that, speeding tickets, these are all citations. Some are handled, like driving infractions and things like that are handled often in traffic courts, but often they are appealable to a higher level criminal court in many jurisdictions. And often they show up in someone's actual criminal history record at the county level. But that's it. We're talking about, when we're talking about a citation, we're talking about something that somebody doesn't typically go to jail for and is usually just payable by a fine. Then there's we hear about people being detained by the police or arrested or being booked. And these are terms that get thrown around. When you're detained by the police, that just means they hold you for a second against your, maybe involuntarily, to ask you questions, and they've got, probably, some sort of probable cause. Now, a detention, being detained by the police may just simply be for questioning in an instant, and then they determine there's not a reason, probable cause to go ahead and arrest you. But once they take you into custody physically and they put handcuffs on you and taking you to the jail, then you're arrested. Okay. I mean, at the point where you can't voluntarily walk away, that's what we're talking about as an arrest. And then the process, somebody says they got booked, that means that they were booked into the jail. It's just like when you walk into the Holiday Inn and you register. It's the same thing with the booking, except that Holiday Inn doesn't take your fingerprints in your photo. But the booking means that, okay, we've created a record of this arrest, and now you're going to be held for whatever the terms are of whatever offense you're being accused of by law enforcement. Now, you got to remember also that just because you're arrested doesn't even mean a case is necessarily going to be filed against you. Sometimes somebody gets arrested and maybe for good cause, but the magistrate judge or the prosecutors look at the information and say, well, this isn't something we're going to pursue for whatever reason. Sometimes it's clear that you did it, but not clear beyond a reasonable doubt, or they don't feel like there's enough information there to proceed with the prosecution, or they just elect not to. There are many cities around the country now where the prosecutors have just told law enforcement, we're not going to prosecute possession for less than 2 ounces of marijuana or something like that. And if that's the case, then somebody may get arrested by maybe an overzealous police officer, but then they get in and the local prosecutor, the DA, is not going to prosecute them, and they never actually get a criminal case filed against them. So just because somebody was arrested doesn't mean that they had a criminal case filed against them. Just because someone is arrested, and we all know this, does not mean that they engaged in the conduct either. It just means the law enforcement believed they did. So whenever we're talking about arrests, one of the things we'll talk about here in a little bit is how important it is for the employer to understand what was going on at the time of the arrest. And that involves the employee participating in the conversation with the employer to really get their side of the story. And then there's the idea of an arrest warrant or a warrant. And this means there's a court order out there that from a judge says, go, tells law enforcement, go get this person and bring them into custody, make them appear before the court. And so an arrest warrant means there has been a judge involved, or a magistrate at the very least involved, and that they're going to, that law enforcement is going to go bring this person in to arrest them and bring them into custody and bring them before the court. And then a criminal case filing happens. So criminal case filing, when you actually get a case number, and that means that the law enforcement's taken their action. They've presented the evidence that they have to the prosecutor, and then the prosecutor will decide, okay, we're going to go ahead and file a case. And this is where most criminal background check information starts. Most of the time, the background checks are looking at the court's records, not law enforcement records. And so what you see is, hey, they filed a case here. And it's a case number, and it may be an open case, so we don't know what the disposition is, or it may have been closed, dismissed, or maybe they were found guilty, or they pled no contest and got a pretrial diversion. All kinds of dispositions are possible out there. But as soon as the case is filed, we've got a case number, and that's usually where your background screening company will see that information for the first time. And I mentioned pretrial interventions or pretrial diversions. These are generally, and it varies from jurisdiction to jurisdiction, but these are generally situations where the defendant, because now they are a defendant, they were an arrested party, and then once the case is filed, they're the defendant, and defending themselves basically against the state, which is trying to prosecute them for this offense. But a pretrial intervention is a program where they file this case, but then the prosecutor makes an offer to the defendant to say, hey, if you'll plead guilty or no contest to this offense, in other words, accept responsibility for the offense, we won't prosecute you. And you'll have to agree to serve probation. Maybe, we're not going to prosecute you. So it's going to show up as a straight dismissed case for, dismissed upon completion of the probation, which may mean community service hours. You see these, and sometimes a lot in domestic violence cases where somebody has to go take an anger management class or a parenting class, things like that. And then the prosecutors will dismiss the case upon completion of whatever the terms of that probation were. But here's the thing. In most jurisdictions, in order to participate in these pretrial intervention or pretrial diversion programs, you have to admit responsibility for the offense. And the reason for that is because you give that admission of responsibility to the prosecutor, and then they can enter that as a plea of guilty. If you screw up the probation, you don't do your anger management classes, you don't do your community service classes, or you get in some other trouble along the way and you get rearrested, then the prosecutor can enter that plea basically, or that plea of guilty or no contest, which means I'm not going to contest or I'm not going to argue my innocence to the court. And very often that means without a trial or anything, they're going to accept that plea that you previously provided and prosecute you. So when I'm talking to employers, I say, we want to consider pretrial interventions and diversions just like any other plea of where they accept responsibility for the offense. Because you as an employer, you don't really care what the outcome of the case was. What an employer really cares about is whether it's reasonable to believe the person engaged in the conduct that was that was what they were accused of. So in that underlying context, what we can care about, and that's the only reason you care about criminal history at all, really, right? It's not, I don't want to hire criminals. It's, okay, this past behavior, these past critical errors in judgment, maybe that these people engaged in may predict how they'll behave in our workplace, given whatever the constraints on the job are, what the risks associated with the job are, what other business controls are in place. And so you care about these pretrial diversions, pretrial interventions, just like you would any other criminal information. And we'll talk more, I think, as we go through here about that. And then there's deferred adjudication, which is very similar. Deferred adjudication, though, is an agreement with the court. The prosecutors, you typically have to agree to it too, but basically a deferred adjudication is where the individual appears before the judge and pleads guilty or no contest to the offense. And then the judge gives them probation of some sort. And again, it could be something as simple as anger management classes. I've seen things where the judges order somebody to finish high school or get their GED, or maybe it's some sort of substance abuse, enroll in Alcoholics Anonymous and attend 20 meetings or something like that. And sometimes it's just stay out of trouble for a certain period of time. And if we're all honest, a lot of us have been on deferred adjudication for traffic tickets, right? And so we don't want it to hit our driving record and run up our insurance. And yeah, they caught me going, 45 into 35. And so I'll just plead guilty, pay an exorbitant fine, but it won't show up on my driving history, so it won't affect my insurance. And that's deferred adjudication. But you can get deferred adjudication for a lot of offenses. I think when we looked last, about 40% of all the cases that were not guilty that we report to our clients were deferred adjudications. So it's a pretty high number. And again, the person's pleading guilty to the offense. So, and it doesn't go away. I hear that a lot. Well, my lawyer said that wouldn't be on my record. Well, no, it is on your record. Deferred adjudication doesn't disappear unless you get it expunged or sealed. And in most states, that's not automatic. Well, I don't think it's automatic in any state, but it's easier in some locations than others. And then there's straight dismissals. And a dismissal means the case wasn't prosecuted for whatever reason. We filed the case, but we didn't go forward with it. Maybe you pled guilty in another case. Maybe you cooperated as a witness in another case, and part of we made a deal and we dismissed this case. Or maybe the prosecutor found that they didn't have enough evidence to prove you did it, or that you were actually innocent of the offense. Those are all dismissals. So as you can see, there are cases at times where a dismissed case doesn't mean the person didn't do it. It just means that the case wasn't fully prosecuted. And either because the prosecutor couldn't do it, or maybe the judge straight dismissed the case because the prosecutor, clearly didn't meet the requirements that the court had for prosecuting the case. It didn't meet all the elements of the law. And again, even there, it doesn't mean the person didn't engage in some conduct that you as an employer might be concerned about. It just means it didn't meet that standard of guilty beyond a reasonable doubt, which is not the standard that that employers generally have to pay attention to in most states. And then we've got the acquittal or the not guilty, which means that this thing went to trial. This case was tried before a judge or a jury, and they found this person not guilty. They were acquitted of the offense. And that's where it means they really didn't do it. Now, there could still, even there, be conduct that you're concerned about. And you should always have a conversation with your candidates about it, because sometimes they are found not guilty, but they will tell you enough about the circumstances. Maybe they were found not guilty because they had to meet these elements of the crime. The prosecutors had to demonstrate this, and there was one that they couldn't demonstrate, and either the judge or the jury basically had to find the person not guilty. But when you talk to your candidate, they say, yeah, and they'll tell you they never did find the gun that I used to shoot that person with, and they, or whatever. Hopefully it's not that dramatic, but they may tell you what conduct they were really engaging in. And sometimes that conduct in and of itself is high risk enough that you as an employer may just choose not to pursue that candidate, or look at your other candidates and evaluate the risks that you've got there. But not guilty does mean that as far as the court was concerned, that person was not guilty legally of all the elements of that offense. And then let's get into, okay, so I'm an employer and I'm finding out that this person's been arrested. What are my legal considerations? That's the first questions that employers pick up the phone and they call their attorney and their counsel, or they call me if they're our clients, and they'll say, so tell me, I just found out Joe's in jail right now. His wife called. That's the call we get, right? Joe's not going to be into work today. And sometimes, they'll tell you, yeah, because he's in jail, or he got arrested and he's not going to be able to come in for a day or two, or till we can, get a bond on him and get him out of jail. Sometimes they're honest, and other times they're not. And they say, he's got the flu. But, I'll get calls from our clients and they'll say, something's weird here. Or sometimes Joe calls in and he says, I'm sick. I'm going to be out a day or two, I think. And then, but you can just hear stuff in the background. And he's like, it's clear he's in a place with a lot of people, and it's something's not right, because when you're making calls in the jail, they often don't give you a private phone booth that's soundproofed, and you hear something doesn't sound like Joe's at home. And so the employer will call us and say, hey, something weird's going on here. And so we do some calling around and check the jails, and there's Joe sitting in jail. And so, but then they want to know, what do we do with this? Well, first we want to go and consider, anytime we're talking about criminal history, Title VII of the Civil Rights Act. Being arrested or being a criminal offender or a former criminal offender does not put you in a protected class automatically. There's no provision under Title VII of the Civil Rights Act that makes, or anything under federal law, that makes somebody in with a criminal history that puts a member of a protected class. That's not the case. But we do need to remember, as was demonstrated in the Green versus Missouri Pacific case in 1975, that minorities are arrested, prosecuted, and convicted at a higher rate than the white population. So if your evaluation of criminal history is kind of cavalier or indiscriminate, and you just say, yeah, anybody who gets arrested, we're not hiring them, or anybody who's got a criminal history, we're not going to hire them, you're going to create a disparate impact on protected classes, very likely. And if you do that, then you're going to be defending yourself down the road against an ESC charge or even a civil case for it. So you want to make sure that, and I've got a whole webinar already on our website just about how to legally evaluate criminal history, and it would go the same for the arrest information under Title VII. And we've got the tools we help employers put together, and they're on the website as well, or in the webinars too, that say, okay, how long ago did this offense happen? What are the risks associated with the job? And how does this offense relate to those risks? Then how many offenses does the person have? And does that change the level of risk that they've got? And that's a whole process and webinar to itself. But what you want to do is, ideally, and this is a big push with all our clients, I really want to see all my clients have policies in place before they ever have to deal with an applicant with a criminal history or an employee who gets arrested. They already know that for this job, this warehouse position, let's say it's a warehouse who drives a forklift, we already know that somebody with a DWI in the last 3 years, we're going to consider them high risk for somebody who's going to drive a forklift in our warehouse. That's just what that policy may be for that employer. So you've already decided before you ever meet the applicant, because quite honestly, you've probably got some hiring managers who think they've got the unique insight into the human soul. And they, and where really what it is where they're introducing bias into the decisions. And so they're saying, oh, this guy's, he looks like me. He's my age. He's got the same level of melanin that I do. So, yeah, we all, he got caught, but we all on occasion might drive drunk, which is probably for many Americans true. But then somebody who's different than him, who comes from a different background than him, it just reconfirms his own biases, and he may not be as forgiving. And so if you've already got a policy that says this behavior is high for this specific kind of job, this behavior is high risk, medium risk, or low risk, then HR can really get involved and really be involved in the process of, as you learn the criminal information, before you even give it to the hiring manager, you can say, okay, this is low risk. Maybe a lot of my clients make the decision that low risk behavior, if somebody's criminal profile marks them as low risk, they don't even tell the hiring managers because they've decided it's not relevant. That theft by check from 5 years ago isn't relevant to this job. Or maybe that DWI for somebody who's sitting behind a desk all day, a single DWI that was more than 3 years ago is low risk. So, but this is all part of the EEOC wants to see employers considering as you evaluate information, including arrest information. The other thing is, and this is always shocking to everybody, but the EEOC says that employers can consider arrest information. And they just say it's got to be reasonable to believe the person engaged in the conduct that was alleged. And so just the fact that an arrest happened doesn't mean the person did it, but the EEOC does say that, well, it makes sense that if it makes sense to the employer and it looks like this person really engaged in that conduct, then it's okay for the employer to use that. So we'll talk about a little bit how we get that information to determine, is it reasonable to believe that? The other question is, well, how did you find out about it? And then who do you tell? So when we're talking about who do we tell about the information, we have to be concerned a little bit about defamation, because how you say things could be defamatory. Now, technically, for something to be defamatory, it has to be said in a way that it has to be wrong, first of all, and shared in a way that when you knew it was wrong and it was shared with intent to harm the person. But do you really want to get into that? Do you really want to get into that whole, and all those arguments about it? So we want to word things carefully when we're talking. There may be people besides HR who need to know about this, or behind, so you might talk to the hiring manager or somebody in risk or things like that, and you might have to tell the supervisor, hey, Joe got arrested this weekend for drunk driving. That is all true. As far as if you've done that much investigation, he was arrested for driving under the influence of alcohol, and so that's true. But when you say they caught Joe drunk driving this week, you don't know if he's really drunk driving. All you know is they arrested him for drunk driving. And so we have to be careful with how we say things. And everyone should be constant. As soon as this becomes an issue, everybody needs to be reminded, first of all, let's protect Joe's privacy to the extent that we can. Nobody needs to know this. And that's not much a legal issue as it is just good employee relations. We don't want to be throwing stuff around, because what if all this turns out to be wrong and half the company is aware that he got arrested? Well, that's going to be a burden that Joe carries, and it's going to affect his ability to perform with his peers, and there's no reason for it to get out there. But at the same time, there are maybe people who need to know. You may have to talk to your risk manager. What is the insurance company going to say about somebody who's currently being prosecuted for drunk driving or a DWI? So that's a conversation you've got to have. You can't keep that insular just to the hiring manager or the supervisor or the or somebody in HR. Maybe you've got to talk to people. So you just got to be careful how you say it, and make sure you're accurate in how you communicate that stuff. Then another consideration is, well, do you participate and cooperate with law enforcement? We've certainly had clients who've had people get arrested, and a detective shows up at the HR office and wants to see the time and attendance records. Was this guy really at work when he said he was at work? They want to see, I've seen them ask for performance reviews. They're trying to figure out what kind of guy this is. Is he having problems at work? What's his financial situation? All kinds of stuff that I've seen law enforcement ask over the last 23 plus years of doing this stuff with employers. And you've got to decide, are we going to cooperate? Because quite honestly, these are your records as the employer. And if a detective shows up and just wants to ask questions, it's your choice whether you cooperate or not. What my recommendation is always refer them to your legal counsel and let your legal counsel decide what information you're going to share. Now, if they show up with a subpoena, which means a court has issued, or at least a magistrate court or a full judge has said, yes, you have to produce these documents, then it's a different matter. But even there, you want to refer them to your legal counsel. That's how I always advise them. I recommend that employers not even talk to detectives about their employees, even to the point of saying, yeah, I'm not, our policy is I won't tell you if when he worked or when he worked last or any of that. You have to go talk to our legal counsel, and then we'll work with them. Detectives may not like it. I've seen them get pretty upset about it, but let's say you cooperate fully, and it's stuff that they try to use against the employee, but then ultimately the case isn't prosecuted and all of that. And now that employee's coming back to work for you, and you've got this awkward situation where maybe you shared information that they'd prefer not to, for you have shared. It's all your call, but just the same, my recommendation is always send it to your legal counsel. The other thing you got to remember is you may get a subpoena for somebody's personnel file or all your records related to this employee. You've got HIPAA concerns there. And in most 98% of criminal cases are filed and prosecuted in state level courts, your local county courts. HIPAA is a federal law and it supersedes those. And so you really want to be cautious if there's any records that reflect medical records of any kind in the employee's file. And you definitely want to work with your legal counsel to make sure that those things are handled appropriately. And then there's going to be times where you find out about an offense, not because the employee told you necessarily or law enforcement showed up, but you've just heard something, right? The rumor mill's out there, and somebody comes and knocks on your door and says, "Hey, I just, Joe's hadn't been to work the last couple of days, and well, I heard this." And so now you're like, great, we don't want to really deal in rumors and speculation, but to protect the company, if it is something that could be relevant to the company's interest, you may need to go investigate. Is Joe really in jail? Did he get arrested this weekend? Or maybe Joe's at work. Maybe Joe's out driving a truck for you, and somebody says, "Hey, I saw that Joe, I saw in a newspaper, or Joe's wife told my wife that he got arrested for drunk driving or for a DWI or whatever." Suddenly, okay, well, we need to look into it and figure out what happened here. Maybe you find out because the employee tells you, and we'll talk about what that policy ought to be, or the employee no calls, no shows, and you do a little research and figure it out, or their spouse calls and tells you. Or maybe you've got an ongoing process of doing background checks on an annual basis for your employees. And you find out well after the fact, 6 months later, that Joe got arrested, had a case filed against him 6 months ago for maybe something as petty as a public intoxication, or maybe it was an assault or domestic violence or whatever. And you find out 6 months later. But at least now and that's the point where we start evaluating what we need to know and what the risk is. And then worst case scenario, you're sitting at home watching the news, and there's Joe. And they say, Joe Smith, who works at XYZ company, was arrested today. And they always seem to throw the employer's name in there. And so, and you're hoping Joe's, booking photo doesn't have your company logo on it or something, but, maybe that's, you find that out. And then the other thing that happens a lot more than certainly than it used to is it's on social media. And I've seen cases where some knucklehead gets arrested, and the first thing he does is get on social media and start bragging about it. And now somebody brings it to your attention, or if you're friends with this person on social media or you follow them, then all of a sudden you're aware of it. So you as HR or as the employer's representative may have a responsibility to follow up and see what risk this may pose to the company. And I mentioned earlier that you should have a policy that says that if an employee gets arrested, it's their responsibility to report to somebody in the organization that they were arrested. And ideally, it's HR and not even their hiring manager. It goes to HR, and then you say you've got to report it to HR within 72 hours of the arrest or immediately upon returning to work, whichever is sooner. And so, and if you've got a no call, no show policy, follow that as well. I've never understood no call, no show policies that are anything besides, if you don't show up for work, we assume you resigned. That's the no call, no show policy I will always advocate for. But if you've got one that's otherwise, and somebody's in jail for 3 days, and yours says if you no show twice, then you're terminated. Then follow your policy. Don't give somebody special consideration because they were in jail. But your policy should say that, hey, you've got to tell us if you've got arrested. And the great thing about that is if you're doing periodic background checks and you find out 6 months later this guy had a case filed against him and he was arrested, or he had a criminal case filed against him, then you don't even have to evaluate the underlying conduct. They've already violated your policy, and it's probably sufficient enough of a violation that you as the employer should be willing to terminate them for not following the policy. And it should be, I'll tell you if your policy should require them to tell you if they're detained, and I've got sample language in the notes. I'm going to send you everybody the notes to the slides. But if they're arrested or detained by law enforcement, if they're aware of law enforcement investigations into their conduct, if they're subject to a temporary or permanent restraining order, and you see those in divorces, but even when those are issued in divorces, you want to know what the context was. Was it related to domestic violence, or was it just simply because we're splitting the assets and I don't want you to take my grandmother's china when I'm not looking? You also want them to tell you about any finding of contempt of court. And we had a case a number of years ago where it was a police officer and no criminal history. And, that's all great. But there were we helped with an investigation, and as we dug into it, we pulled, he had several civil cases of divorce and some related to that, some other civil litigation. And we found he was found in contempt of court in 2 cases. And that is a real problem for a law enforcement agency. How do you have somebody who's been found in contempt of court as testify before a court about somebody else's conduct, and what they, the defense could easily use that kind of information to undercut that officer's credibility in front of a jury. And so that would be a concern for an employer in certain situations, even there. And so if they have a contempt of court finding, your policy should probably say, hey, you need to tell us about those things. And then certainly anytime a criminal case is filed, even if they don't get arrested or haven't been arrested yet, but they're aware that a criminal case is filed, that's not something minor like a traffic infraction, moving violation, then they should report that to you. And my belief is it should be immediately upon return to work or within 48 or 72 hours. And there's other ways you find out. Of course, it's like I mentioned, just doing annual background checks. Probably a good number of our clients, maybe a third of them, do some sort of ongoing background check on employees. And that may just be the driving history. If this person drives or operates heavy equipment, we have a lot of employers who just pull their driving history on an annual basis, just to make sure that they're not, that they're continuing to operate in a safe manner outside of the workplace, so that when they're behind the wheel of a car, a forklift, or any kind of equipment like that on the work site, then they know that, they can demonstrate that, hey, we try to mitigate the risk by checking that. Other clients do just a small criminal background check. They don't have to do the full-blown criminal background check like we do when somebody first gets hired, You don't need, you don't need to go recheck where they lived 2 years ago, 5 years ago, 10 years ago, but where they've lived in the time since we did our last background check. Makes sense to check those locations and then check the databases and other sources that may point to another criminal case, because people don't always get in trouble where they live. And so sometimes searching state or multi-jurisdictional criminal databases can be helpful as well. So now we're pretty sure this guy really had an arrest. And our question then is, what do we do about it? Well, the first thing is to investigate it. And the first step in any investigation is the part most of us hate, the documentation. And you just got to document everything. Document how you learned about it. Was it the employee? How did you hear about it? What did you do to try to confirm it? Who did you talk to? Collect all that information, because you never know down the road when you're going to have that conversation with or have to testify about something or be in a deposition about something that happened. And you just want good documentation. It makes your life just a lot easier. And one thing I should have mentioned earlier when we're talking about the employee self-reporting policy, often the employee's attorney is going to tell them, you don't talk to anybody about this. And we'll talk about it some more in a little bit, but be ready to hear that from the employee. Well, my lawyer said not to talk to you about it. And that comes up a lot. And when we'll talk about it in a little bit. I just popped in my mind. And I thought I better mention it. Then I realized I've got a slide on it. You also need, if it's high profile, if this arrest is already on the news, or it has the potential to be on the news, a big, like big embezzlement cases, or some sort of physical violence or sexual assault. If it's something like that, we need to have a communications plan in place. And it doesn't mean we're going to immediately distance ourselves from this employee, but what it might mean is that, well, we do need to think about, as a company, what does this mean for the company's reputation? What does it mean? Even if the person did engage in the conduct, we need to protect one of our biggest assets as a company is our reputation in the community. And do we really want Joe Smith, who works for XYZ in this particularly sensitive position, all over the news as still working for us? There may be some situations where you say, yeah, we don't want, we operate a restaurant. And it's a pretty public, high profile restaurant. And this guy's all over the news because of some offense and he's a server here. Maybe we say, we just can't have a server dealing with the public when the public may recognize this person, from the news. And so, but who's going to communicate with the news? Who's going to have those conversations, and who's going to do that? And it's really key that's only one person, that everybody else knows that they have no comment. You need to talk to HR, or you need to talk to legal, or our PR department, or whoever it is, and who's going to handle the communications on the behalf of the company. Especially if news cameras just suddenly show up on the front door at your office. And so we've got a plan in place. We know what our policy says, and now we're going to look at how do we respond? Well, it's first thing we're going to look at is what's our no call, no show policy, and have we already violated that? And if he has, then maybe that's your answer, and we're just going to follow that. But maybe we're going to say, okay, yeah, Joe comes in on Monday morning and says, hey, I got a DWI this weekend, and I'm going to fight it. And you say, okay, well, all Joe does in our organization is drive a desk. He sits, behind the desk all day, and this is really low risk. So yeah, we're going to provisionally let Joe come back to work until we understand more about what's going on. But maybe it's something that is directly work related, and we need to do a deeper internal investigation, and something related to one of our suppliers or a customer. Suddenly, maybe we need to do a lot more internal investigation, see who else knows things and who's involved. In some cases, where depending on the environment, so let's say you're in healthcare, facility, and he's been in this employee has been charged with sexual assault. That may be just immediate suspension. Maybe we're not going to terminate them right away, but we're going to put them on some sort of paid or unpaid, depending on your policy, leave until this is resolved, until you've completed the investigation and made a decision, or the case is resolved. And in some cases, you may just have to terminate them. Like I said earlier, it could be a circumstance where that person's conduct is so clear. Maybe it's somebody got a video of him beating up an old lady, and or kicking a dog or whatever, and you say, yeah, we can't have that in our representing our company, and you just have to say, based on just the basic information, we're going to have to terminate. But whatever the employee tells you, part of your plan needs to be, we're going to verify it, because you can't just go by what the employee told you. Then what do you do about the employee who says, as I mentioned earlier, my lawyer said not to talk to me about it, I have to plead the fifth? Well, if you're a private employee and you're not a local government or a state employee or federal employee, if you're a private employer, they don't have Fifth Amendment rights. They don't have a right against self-incrimination when they're talking to the employer. Now, here's the thing. Whatever they tell you is subject to subpoena by law enforcement, right? So if you have them write down, and I always want these conversations written down, I never want a verbal conversation to be relied upon. So if I'm sitting down and talking to Joe about what happened, and it at all seems relevant to the job, I'm going to have Joe write it all down. And he's going to have, and tell me what happened, not just that I was arrested for this, but did you engage in that conduct? How many drinks did you have before you got behind the wheel? What happened there? Because you're trying to protect the company here. You're trying to evaluate if there's risk here for the organization. And so you need to understand what Joe's side of the story is. That's only fair to Joe to get that side. Now, Joe, if he is smart and he's going to listen to his attorney, but they often don't, he's not going to tell anybody anything. He shouldn't, just to protect his own interest. But you probably have a policy that says that the employee has to cooperate with any investigation into, violations of company policy, practice, or the law. And so if Joe refuses to cooperate with your investigation, then you may have to make a decision that we can't, that's a violation of our company policy. And I'm sorry, but in order to protect the company, we have to conduct this investigation, and we can't do it without your participation. And that's, now if you're a local government or a state or a federal employer, you need to really talk to your counsel about at what point does something become a violation of Fifth Amendment, which is their right to, against self-incrimination. But talk to your counsel and make those decisions at that point. But if you're a private employer, you need Joe to tell his side of the story in order to fairly evaluate this. And then we do our investigation and we try to figure out, were there other employees involved? What's our customer exposure? What's our vendor exposure? Or what's the company's exposure to this? How are any of those things involved? Because sometimes if it's an embezzlement case or some sort of fraud, or even if it's depending on your industry, maybe you're a subcontractor to a bigger contractor, and it's going to implicate something in your contract or your agreement, or your contractor, your major customer, will not be interested in having having this kind of visibility, or maybe you've got contract agreements that say that you won't have anybody with these kind of offenses working for you. So you just need to look at all those kinds of issues. What kind of restrictions are placed on the employee? For instance, do they have to wear an ankle monitor? Maybe that's a condition of their bail. They have to wear an ankle monitor, and maybe they're allowed to go to work, but they have to wear the ankle monitor. And maybe in your environment, they're facing the public. I don't know that, if I was visiting my local bank branch and I saw that my banker was walking around with a big hunk of plastic around their ankle, that may give me pause about that. So if it's a public facing position, or even if it's internal, and you'd be concerned about having that kind of visibility, maybe that's a game changer. Whether with whatever restrictions, maybe he's not allowed to drive, maybe he can't be within 500 feet of a school as a condition of his probation, but that affects his ability to do the job. So you need to evaluate those kinds of things. And then availability for work. Can Joe actually be here at work? Because often when somebody's out on bail, they have to make court appearances. Maybe he can't travel while he's out on bail, and you need him to travel, or he needs to be in meetings, but he's got court appearances and things like that. Or maybe he's got a pretrial diversion of some sort, and has to go to anger management classes and do these things, whatever it is, or community service, and he can't do it off, at a time where he's not supposed to be at work. All those kind of issues you have to evaluate. Are these things that make a difference in whether we can continue with Joe? Because your standard as an employer isn't guilty beyond a reasonable doubt. Again, the standard is just, is it reasonable for you to believe that person engaged in that conduct? And what is the impact on the company? So even if there are situations where, even if you really don't think this person necessarily did that, it seems totally out of character, and he's protesting his innocence, but having that visibility associated with your organization could damage the company's reputation. Then you may have to make those decisions where that we have to do something differently. Then there's always the option of what your policies say. What's the work environment? Does this guy work by himself? Is this a remote position, as so many of them are now? Is this somebody, I'm not concerned that he's, maybe it's an assault offense, and I'm not concerned with Joe interacting with other employees because he sits at home on a computer all day long. And so he can continue to work that way. We've talked about the risks associated with the position. Does he drive or operate heavy equipment, or does he interact with the public? Or does he manage client accounts? Those could present different kinds of risk for different kinds of offense. And so we need to look at those. You also may have a CBA, a collective bargaining agreement, that you need to pay attention to, because there may be specific processes you follow according to your CBA. If you're civil service, if you're a public employer with civil service rules, you may have to look at those and see what that process looks like, and how you can respond legally or in compliance with the civil service rules. You might also look at the employee's past performance and figure out what, given their past performance and how, what the performance reviews look like, what their actual performance looks like, how long they've been with the organization. All of those things may factor in. If you've got a new employee who on day 1 or day 3 or day 5 or the first month gets arrested, and it seems credible, and it's like this guy is not managing his own business pretty well, you may be a lot less forgiving of that person than that employee who's been with you for 15 years and been tried and true and always had good performance. And now now they've gotten some trouble. You may give more balance and let that relationship affect your decision. And I think that's a perfectly valid business reason. You've got a lot invested in this relationship at this point. And if this is an employee that you really want to save as far as keeping on the payroll and keeping in a productive role over the long term, you may make that choice. You also need to look at what else, as always, anytime we're looking at any kind of behavior like this, is there any chance of a retaliation or a discrimination claim? If there's already, like if last week you had a complaint, a sexual harassment complaint received from this employee, against a manager. And now this week they got into some sort of criminal, in trouble. That doesn't, the two things shouldn't in the real world be related, but we have to look at it, right? We have to say, okay, what will it look like? And what's our documentation to demonstrate that these two things are unrelated? That, that our policy says that here's how we do the investigation and here's what the investigation said. And it's totally unrelated to that previous claim. You just have to, in the HR world that we live in, that's always a consideration. It's always one of the first questions I ask. Is there anybody, when I'm doing an investigation for an employer, when I first, I'm screening the client to see if it's even a case I want to take, I always want to know, okay, are the parties in, anybody in a protected class, anybody already in a progressive discipline process, or filed some sort of complaint, any of those kinds of things. I want to know the lay of the land. And that's what this part is. As you make your decision, you want to know those things. And then we got to decide how are we going to respond. While this case, we're still talking about arrest. We're not even talking about a case that's been prosecuted and convicted, into the case. Is the employee going to be allowed to return to work? And what does that mean? Does it, we've kind of proven and we can have employees work from home. And so maybe that's what we do. We let them continue working, but they work off site, depending on what the offense was and what their job is. What accommodations are we willing to make? If they have to have, once a month, they have to have an afternoon off so they can go do a drug test or make court appearances and things like that. Are we willing to do that? And willing to schedule around those things? And you need to have those conversations with the employee right up front about those things, because that expectation, once you say, yeah, you can come back to work and just let this work out, the expectation is, from the employee at least, that you're going to be forgiving of those kinds of things. And so you need to have the conversation. You can, and you may well say, we'll do this, but if it becomes too disruptive, we'll have to make a different decision. And then you also want to continually verify the status of that case against court records, because you're telling the employee, well, keep us updated on the case. And you're letting them return to work, or they're working remote, whatever. Or you're suspending them, but you're not terminating them. You're saying, we're going to suspend you for some period of time. But the problem with suspending them is this could be 18 months, 2 years down the road. You're going to keep somebody suspended 2 years while their case slogs through the criminal court system. It's, do you really want them on your policies, on your insurance, all of that during all that time? If you've got them suspended, I recommend usually against that until, you might suspend temporarily while you do the initial investigation. But once you've determined that, yeah, it's reasonable to believe they engage in this conduct, or there's a higher level of risk to the company's reputation or something like that, or key contract relationships and things like that, then we may just have to, we got to make a decision. We can't keep somebody, on an indefinite suspension for multiple years. But if they are suspended, or you've let them return to work, even with some accommodations, you still need them to keep you up to date on the status of the court record. So when their next court hearing is, or certainly if they enter in some sort of plea deal or whatever. But also have your background check company at least once a month, at least go check the status of those records. It's funny how employees will tell the employer up front they've got this issue, and then the employer never, HR or whoever, never follows up to see what happened later on. And when they don't follow up with what happened later on, suddenly the employee says, oh, well, I'm going to be gone for the next 6 months because I got caught, I got convicted. And so not having that information, not checking on a consistent basis, can put you at risk. Especially think about it, if they plead guilty and get deferred adjudication, the case is closed now and they can come to work, but they pled guilty to an offense. And there's on our Bad Hire Days website, there's a story about somebody who got convicted of and got deferred adjudication for a computer crime, while he was the administrator of another company's computer system. So we want to pay attention to those. We talked about modified work conditions. Maybe we let them work from home, maybe suspending them so they can just hang out and wait. But again, you don't want those suspensions to last too long. You don't want to just have these employees on your books, but not actually being worked. And of course, you always have the issue that you may have to terminate them, and that may just be the final straw. And then finally, recertification credit. Thank you for joining me today. So if you're watching this live on March 10th, 2022, you're going to get an email from us with HRCI and SHRM recertification information tomorrow morning. You'll get it this afternoon or tomorrow morning. But if you're watching the recorded version, thank you for doing that. And just below this video, there's a form to fill out, and it's going to ask for a code word to kind of prove that maybe you watched this and paid attention. And so the code word is arrest, right there, arrest. And so when it'll ask for your name and contact info, and you put arrest in there, and we will give you the HRCI and SHRM research information that way. And finally, if you want just more gospel according to Coffey, a couple things. First of all, we've got the book, 7 Steps to Bulletproof Hiring Decisions. And this is just what I think, some things that employers, where they drop the ball in hiring people. It's not just background checks. Background checks is like one piece of it, but we talk about the criminal history inquiry, kind of the whole process, the whole screening process, which I think starts with before you've ever met the candidate, with your policies, with your evaluation of the risk associated with the job, all those other things. And then at the end, how you talk to your applicant about criminal history, how you evaluate that criminal history, and then how you verify what the applicant told you. So that's that. And also, because I forgot to put a slide in there, Good Morning HR, my podcast. Every Thursday morning, we drop a new episode, and each episode of Good Morning HR is good for half a research credit from HRCI and SHRM. So you can get, over the year, 26 research credits just by listening to me talk for 30 minutes or so to smart people. And that's my skill set, asking dumb questions of smart people. And so it's goodmorninghr.com, or on Apple, Stitcher, Spotify, wherever you listen to your podcast, also on YouTube. And like I said, they're all worth half of a research credit as well. So if there are any questions, I'll answer them. I don't see any yet, but my contact information is all right here. So if you have questions, feel free to shoot me an email, and I'd be glad to answer them. But until then, I hope you'll join me on the podcast, and be well, do good, and keep your chin up. See you next time.